I want to tell the story of a hearing this morning, February 3rd, 2021. I'm, assisting my elderly boss, who's been a lawyer almost 60 years in Florida, Richard, in attending a hearing via Zoom. And, I get there at 8:30 just to make sure. He has me on hand to make sure that he's able to log in. Because, it can be technical challenges with so many passwords and stuff like that. And he is 81. So, but he's conscientious about it, and that's why I'm there. Not that I'm the ultimate IT guy, but I know damn sure well how to log into Zoom. So, what happens is, the hearing's at 9:05. We're logged in like 8:58. I know we're in the right place because it says, in the middle of our screen, waiting for host to admit you or initiate the meeting. It says the name of the judge, Butchko, got that right, Butcher, and the name of the case, and the time the hearing's going to start. So we're sitting there waiting. It's up on his screen. I log him in directly. I directly do it. I type the Zoom, whatever, address with all the numbers after it, the Zoom meeting ID, into the address bar at the top of the browser, and it goes right to it. So I'm kind of sitting across from him at this table where we work, and I was watching the clock. I remember seeing it be 9:04, and I remember waiting a little while longer because I said eventually, probably around 9:07 or 9:08, I said, I think the judge is coming to court this morning. And about 9:09, all of a sudden, my boss gives me the panic wave, and I come over and look over his shoulder, and his screen has gone to screensaver, where it has that damnable rectangle in the middle, and it wants you to enter your PIN. And he does face recognition. He doesn't have a PIN because he has so many of them, and it's hard to keep track of it, so he's trying to upgrade. He has it set up for face recognition, which normally works fine. Well, this time, for the first time in history, as far as I know, for us, it says, cannot use Face ID, camera in use. So he tried 2 or 3 PIN numbers. We tried, it has a link that says sign in options. We tried all of those, and it just kept on reverting us back to the PIN. So at that point, I said, well, just come down to the other end of this table, and I'll log you in through my computer. So we log in quickly to my computer. By this time, it was probably 9:15, unfortunately. We really, it was already almost 9:10, and we were waiting for the judge. So if she was 4 minutes late, we were 5 minutes late after that. But when we logged in, she screams at my boss, "Why are you late? I see, who's Kenneth Trent?" I had to use his computer, Judge, because we're having a problem. "Oh, where were you? Where were you? I called your cell phone, Mr. Chosid. I called your cell phone. I left you a message. Where were you?" And he's like, "Well, we put it on silent prior to the beginning of the Zoom hearing so that we wouldn't upset you if the phone rang during the hearing." She says, that's not true. That's not true because you, never mind, it doesn't matter. Well, the plaintiff has already finished its presentation. Do you have anything to say? And then she says, "I see you filed a memorandum in opposition to the motion for summary judgment, but it's not sworn. It's not sworn, so, we don't have to consider it or whatever. There's no requirement that a memorandum of law be sworn. They have to carry their initial burden. They have to meet the minimum procedural requirements to actually present a motion for summary judgment to the court. 1.510E says, and this is all to be very strictly construed, that the affidavit filed in support of a motion for summary judgment, if it's by a business or on behalf of a business, and it gives, for example, the total amount due, there must be attached to that affidavit the actual records upon which the affiant, that is the person signing the affidavit, relies. So we need to see what records it is. Review of the business records establishes that you owe us $10 billion. Okay, well, you have to attach those business records, and you have to say in the affidavit, the attached business records are true and correct copies of the actual records of Ceteris or whatever. And we don't do that. Like, like you can't just file the papers or carry them into court with you. They're supposed to be sworn evidence because the judgment is going to be granted directly upon those. And, I mean, there's a gazillion cases. It says the defendant does not have to come forth with any evidence whatsoever until the plaintiff carries its heavy burden to establish that it's met the procedural and technical requirements, such as attaching the records to the affidavit and having the affidavit certify in the affidavit that the documents are true and correct copies of the real thing. They didn't do any of that. They went to court against my client pro se on September 20th, and the judge bent over backwards for the pro se black client of mine, my friend. Now, when we tell him that she was a raging hyena, to him it doesn't make any sense because she was pretending to be gracious to him. But anyway, she threw him a bone last time and told them, like, hello. She did her job because they had an affidavit saying how much was owed, but there were no business records attached. So she gave him the break by saying, okay, I'm going to defer on that. Go ahead and file your payment history or whatever to show how much money is owed, and then you can reschedule your hearing. Well, then he hired us. And you know what they did? They just sent in the records. Notice of filing, whatever, blah, 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 some fake-ass records. Well, guys, that's not summary judgment material. It's not evidence. It's not evidence under the Florida Rules of Civil Procedure. Specifically, including the one directly controlling all summary judgment procedures. This circuit civil judge doesn't know that? What the...